Okay, so our topic for today is about legal, ethical, and professional issues in information security. So, upon the completion of this lesson, you should be able to describe the functions of the relationship among laws, regulations, and professional organizations in information security. Differentiate between laws and ethics. Identify major national laws that affect the practice of information security, and explain the role of culture as it applies to ethics in information security. As a future information security professional, you must understand the scope of an organization's legal and ethical responsibilities. The information security professional plays an important role in an organization's approach to managing liability for privacy and security risk. In the modern litigious societies of the world, sometimes laws are enforced in civil courts where large damages can be awarded to plaintiffs who brings suits against organizations. Sometimes these damages are punitive, assessed as a deterrent. To minimize liability, reduce risk from electronic and physical threats, and to reduce all those losses from legal actions, information security practitioner must thoroughly understand the current legal environment, stay current with law and regulations, and must for new and emerging issues. By educating the management and employees of an organization on their legal and ethical obligations and the proper use of information technology in information security, security professionals can help keep an organization focused on its primary objectives. Law and ethics in information security. In general, people elect to trade some aspect of personal freedom for social order. Law are rules that mandate or prohibit certain behavior. They are drawn from ethics, which define socially acceptable behaviors. The key difference between laws and ethics is that laws carry the authority of governing body and ethics do not. Ethics in turn are based on cultural mores and fixed moral attitudes or customs of a particular groups. Some ethical standards are universal. Let's say, for example, murder, theft, assault, and arson are actions that deviate from ethical and legal codes throughout the world. Organizational liability and the need for counsel. What if an organization does not demand or even encourage strong ethical behavior from its employees? What if an organization does not behave ethically? Even if there is no breach of criminal law, there can still be liability. Liability is the legal obligation of an entity that extends beyond criminal or contract law. It includes the legal obligations of make restitution or to compensate for wrongs committed. The bottom line is that if an employee acting with or without the authorization of the employer performs an illegal or unethical act that causes some degree of harm, the employer can be held financially liable for that action. An organization increases its liability if it refuses to take measures known as due care. Due care standards are met when an organization makes sure that every employee knows what is acceptable or unacceptable behavior and knows the consequences of illegal or unethical actions. Due diligence requires that an organization makes a valid effort to protect others and continually maintains this level of effort. Given the internet's global reach, those who could be injured or wronged by an organization's employees could be anywhere in the world. Under the U.S. legal system, any court can assert its authority over an individual or organization if it can establish jurisdiction. That is, the court's right to hear a case if a wrong is committed in its territory or involves its citizenry. This is sometimes referred to as a long-arm jurisdiction. The long arm of the law extending across the country or around the world to draw an accused individual into its court system. Trying a case, an injured party, some area is usually favorable to the injury party. Policy versus law. Within an organization, information security professionals help maintain security via the establishment and enforcement of policies. These policies, guidelines that describe acceptable and unacceptable employee behaviors in the workplace, functions as an organizational laws, complete with penalties, judicial practices, and sanctions to require compliance, because these policies functions as laws and they must be crafted and implemented with the same care to ensure that they are complete, appropriate, and fairly applied to everyone in the workplace. The difference between a policy and a law, however, is that ignorance of a policy is an acceptable defense. Thus, for a policy to become enforceable, it must meet the following 5 criteria. Number 1 is dissemination. Review, comprehension, and of course, compliance and uniform enforcement. Okay, so when we say dissemination, the organization must be able to demonstrate that the relevant policy has been made readily available for review of the employee or by the employee. Common dissemination techniques include hard copy and electronic distribution. Review or reading. The organization must be able to demonstrate that it is disseminated the document in an intelligible form, including version for illiterate, non-English reading, and reading impaired employees. Common techniques include recordings of the policy in English and alternate languages. So let us say, for example, in the Philippines, recorded in English and in Tagalog or Filipino. Comprehension, understanding. The organization must be able to demonstrate that the employee understood the requirements and content of the policy. Common techniques include quizzes and other assessments. Compliance or agreement. The organization must be able to demonstrate that the employee agreed to comply with the policy through act of or affirmation. Common techniques include log-on banners, which require a specific action, to acknowledge agreement, or sign document clearly indicating that the employee has read, understood, and agreed to comply with the policy. And the last one is the uniform enforcement. The organization must be able to demonstrate that the policy has been uniformly enforced regardless of employee's status or assignment. Only when all of these conditions are met can an organization penalize employees who violated the policy without fear or legal retributions. Types of law. Civil law comprises a wide variety of laws that govern a nation or state and deal with the relationship and conflicts between organizational entities and people. Criminal law addresses activities and conduct harmful to society and is actively enforced by the state. Law can also be categorized as private or public. No? Private law enforcers encompasses family law, commercial law, and labor law, and regulates the relationship between individuals and organizations. Public law regulates the structure and administration of government agencies in their relationship with citizens, employees, and other governments. Public law includes criminal, administrative, and constitutional law. Relevant U.S. laws, actually, historically, the United States has been a leader in the development and implementation of information security legislation to prevent misuse and exploitation of information and information technology. The implementation of information security legislation contributes to a more reliable business environment, which in turn enables a stable economy. In its global leadership capacity, the U.S. has demonstrated a clear understanding of the importance of securing information and has specified penalties for people and organizations that breach U.S. civil statutes The sections that follows present the more important laws that apply for information security. The general computer laws. There are several key laws relevant to the field of information security and or particular interest to those who live or work in the U.S. The Computer Fraud and Abuse Act of 1986 is the cornerstone of many computer-related federal laws and enforcement efforts. It was amended in October 1996 by the National Information Infrastructure Protection Act of 1996, which modified several actions of the previous act and increased the penalties for selected crimes. The punishment for offense prosecuted under these statutes varies from fines to imprisonment up to 20 years or both. The severity of the penalty depends on the value of the information obtained and whether the offense is judged to have been committed. Number one, for purpose of commercial advantage, for private financial gain, and in furtherance of a criminal act. The privacy. Okay, so the privacy. Filipinos spend an average of 10 hours and 2 minutes each day online. So the highest in the world according to the recent data. So the Philippines also tops social media use for the 4th straight year. Vast amounts of personal information from Philippines, including photos of daily activities, are freely circulating the web. So in 2012, the Philippine passed Republic Act 10173 or the Data Privacy Act of 2012 to protect the fundamental human right to privacy or communications while ensuring free flow of information to promote innovation and growth, and inherent obligation to ensure that personal information in information and communication systems in government and the private sector are secured and protected. The DPA was passed in accordance with Philippines Agreement under ASEAN Vision 2020 and at the urging of the growing business process outsourcing industry. The law was modeled after the Data Protection Directive with many of its terminologies and provisions similar to privacy laws in other jurisdictions. The DPA, in its implementing rules and regulations, apply to all acts done or practices engaged in and outside the Philippines. If the person, either an individual or an institution involved in the processing of personal data is located in the Philippines, the act or practice involves personal data of a Philippine citizen or Philippine resident, the processing of personal data is done in the Philippines, or the act, practice, or processing of personal data is done by an entity with links to the Philippines, subject to international law and committee. Personal data refers to all types of personal information, and processing is any operations or performed upon personal data, and these operations include but are not limited to the collection, recording, organizations, storage, updating or modifications, retrieval, consultation, use, consolidation, blocking, erasure, or destruction of data. So the National Privacy Commission is in charge of administering and implementing the Data Privacy Act. It is also tasked to monitor and ensure compliance of the Philippines with international standard for personal data protection. So the major functions of the National Privacy Commission are as follows: rulemaking, advisory, public education, compliance and monitoring, complaints investigation, and enforcement. Personal information control is an individual or institution or any other body who controls the processing of personal data or instruct another to process personal data on its behalf. The law requires a data breach notification within 72 hours upon knowledge of the breach or reasonable belief that it has occurred to the National Privacy Commission and the data subject. The notification is generally required when the breach involves sensitive personal information or any other information that may be used to enable identity fraud. This information has been acquired by an unauthorized person, and the acquisition is likely to give rise to a real risk of serious harm to the affected data subject. The National Privacy Commission may investigate the breach depending on its nature, or there is a delay or failure to notify. Inquiries may include on-site examination of systems and procedures. The Philippines has a relatively young data privacy regime. The Data Privacy Act as well as RA number 10175 or the Cybercrime Prevention Act was only enacted in 2012, although some countries passed data privacy laws as early as the 70s. So the Philippine regulatory body, National Privacy Commission, was formally organized only in 2016, which issued IRRs and circulars in the same year. Nevertheless, the country is on its way to developing a stable framework of privacy protection as technological innovations liberalize information sharing and need help with your data security. Privacy for customer or customer informations. Some regulations in the country legal code stipulate the responsibility of common carriers, organizations that process or move data for hire to protect the confidentiality of customer information, including that of other carriers. The privacy of customer information section of the common carrier regulations state that any proprietary information shall be used explicitly for providing services and not for any marketing purposes. In that, carriers cannot disclose this information except when necessary to provide their services. The only other exemption is when a customer requests the disclosure of information, and then the disclosure is restricted to that customer's information only. This law does allow for the use of aggregate information as long as the same information is provided to all common carriers and all carriers possessing the information engaged in fair competitive business practices. Aggregate information is created by combining pieces of non-private data often collected during software updates and via cookies that when combined may violate privacy. Before that, the Electronic Communication Privacy Act of 1986, it is a collection of statutes that regulates the interception of wire, electronic, and oral communications. These statutes work in conjunction with the Fourth Amendment of the U.S. Constitution, which protects individuals from unlawful search and seizures. The Health Insurance Portability and Accountability Act of 1996, or HIPAA, also known as the Kennedy-Casaubon Act, protects the confidentiality and security of healthcare data by establishing and enforcing standards and by standardizing electronic data interchange. HIPAA affects all healthcare organizations, including doctors, practices, health clinics, life insurers, and universities, as well as some organizations that have self-insured employees' health programs. The privacy standard of HIPAA severely strict the dissemination and distribution of private health information without document consent. The standard provides patients with the right to know who has access to their information and who has access to it. The standards also restrict the use of health information to the minimum necessary for the healthcare services required. HIPAA has 5 fundamental principles. Number 1, consumer control of medical information, boundaries on the use of medical information, accountability for the privacy of private information, balance and public responsibility for the use of medical information for the greater good measured against impact of the individual, and security of health information. The Financial Services Modernization Act, or Gramm-Leach Bliley Act of 1999, contains a number of provisions focusing on facilitating affiliation among banks, security firm, and insurance company. Especially, this act requires all financial institutions to disclose their privacy policies on the sharing of non-public personal information. It also requires due notice to customers so that they can request that their information not be shared with third parties. In addition, the act ensures that the privacy policies in effect in an organizations are both fully disclosed when a customer initiate a business relationship and distributed at least annual for the duration of the professional associations. So this will be the key U.S. law of interest to information security professionals. There are for telecommunications, freedom of information, privacy, copyright, cryptography, access to stored communication, threat to computers, Federal Agency Information Security, trap and trace restriction, criminal intent, trade secrets, personal health information protection, encryption and digital signatures, and intellectual property. Actually, in the Philippines, we have Data Privacy Act. We have also Cybercrime Act, and so on. And I think it will be able to discuss by our presenter in Data Privacy Act and other legal issues. They have also copy protections, identity theft, banking, terrorism, and accountability. Spam, fraud with access devices, and terrorism and extreme drug trafficking. Export and espionage laws. To meet national security needs and to protect trade secrets and other state and private assets, several laws restrict which information and information management and security resources may be exported from the U.S. These laws attempt to stem the theft of information by establishing strong penalties for this crime. Under Philippine law, original intellectual creations in the literary and artistic domain are copyrightable. These include books, pamphlets, articles, and other writings, periodicals and newspapers, lectures, sermons, addresses, dissertations prepared for an oral delivery, letters, dramatic or dramatico-musical compositions, choreographic works, or entertainment in dumb shows, musical compositions, drawing, painting, architecture, sculpture, engraving, lithography, models or design for works of arts, original ornamental designs or models for articles of manufacture, illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture or science, drawing or plastic works of a scientific or technical character, photographic works, including works produced by a process analogous to photography, lantern, slides, audiovisual works, and cinematographic works and works produced by a process analogous to cinematography or any process for making audiovisual recordings, pictorial illustration, and advertisement in computer programs. Derivative works are also protected as new works, provided that it does not affect the existing copyright on original works. Derivative works may include dramatizations, translations, adaptations, abridgment, arrangement, and other alterations of literary music works, collection of literary, scholarly, or artistic works, and compilation of data and other materials which are originally by reason of the selection or coordinations or arrangement of their concern. Copyright protection does not cover some idea, procedure, system, method, or operations, and others. So, in the Philippines, copyright protection for artistic, literary, and derivative works lasts during the lifetime of the author plus 50 years after the author's death. This term of the protection also applies for posthumous works. In the case of joint authorship, the economic rights shall be protected during the lifetime of the last surviving author plus 50 years after such author's death. In case of anonymous or pseudonymous works, copyright protection shall last at 50 years from the date on which the work was first lawfully published. If the work was not published, it shall be protected for 50 years counted from the creation of the work. So, what constitute copyright infringement in the Philippines? So under Philippine law, copyright infringement occurs when there is violation of any of the exclusive economic or moral rights granted to the copyright owner. It may you also consist in aiding or abetting such infringement. The IP code also provides for the liability of a person who, at the time when copyright subsists in a work, has in his possession an article which he knows or ought to know to be an infringing copy of the work for the following purposes. Letter A, selling or letting for hire or by way of trade offering or exposing for sale or hire the article. And letter B, distributing the article for the purpose of trade or for any other purpose of an extent that will prejudice the rights or prejudice the rights of the copyright owner in the work, or letter C, trade exhibit for the article in public. So what are the remedies available to owner of a copyright against an infringer? The copyright owner can file a criminal, civil, or administrative action to copyright infringement. A criminal case for copyright infringement must be filed in the court stipulated in the place where the violation occurred. The administrative suit is filed at the Bureau of Legal Affairs and Intellectual Property Office of the Philippines. A civil infringement lawsuit is filed in the appropriate court located at the place where the defendant resides is located, or where the plaintiff resides is located at the option of the plaintiff. Freedom of Information Act of 1996. The Freedom of Information Act allows any person to request access to federal agency records or information not determined to be a matter of national security. Agency of the federal government are required to disclose any requested information on receipt of a written request. This requirement is enforceable in court, and some information is, however, protected from disclosure, and the act does not apply to state or local government agency or to private businesses or individuals. Although many states have their own version of Freedom of Information Act. In the Philippines, Executive Order Number 2 on the Executive Order of the Freedom of Information aims to promote an open government by increasing the transparency of the executive branch and its agencies. It strengthens the right to information as enshrined by the Constitution. Freedom of information allows Filipino citizens to request any information about government transactions and operations, provided that it shall not put into jeopardy privacy and matters of national security. The freedom of information mechanism for the executive branch is enabled through Executive Order Number 2, Series of 2016. On the other hand, temporary migrants or overseas Filipino workers are not required to register with the CFO before the departure from the Philippines. They are instead required to register with obtain their overseas employment certificates from the Philippine Overseas Employment Administrations. The Freedom of Information Act approved by the Senate on December 14, 2009. The Senate of the Philippines approved the Freedom of Information Act designed to allow access to key public documents, including those related projects where corruption has been an issue. So the act found in Senate Bill number 3308 requires government agencies to allow public review and copying of all official information. Officials who block public access are subject to a term of imprisonment of from 1 to 6 months. The only time access to information may be denied are when the information must be kept secret under executive order guidelines, when the data is related to internal and external defense or law enforcement, and its public scrutiny would compromise anti-crime activities or put the safety of the protected source, witness, law enforcement, or military officers or family members of those officers in danger. When the information is of the personal nature related to someone other than the requesting party and its release would compromise that person's privacy. When disclosed, would open trade, industrial, financial, or commercial secrets. When the information is privileged by law or a court ruling from productions in legal proceedings. When the information is exempted from freedom of information request by law or constitutional provisions. When the information had been obtained by either house of the legislature and executive sessions, or when the items requested are drafts of executive, administrative, judicial, or quasi-judicial decisions, if their public release could reasonably be seen as obstructing the administration of justice, such as impairing the impartiality of verdicts. Decision to deny release of information must be made in writing or through electronic communications within 7 days of the receipt of the original request. However, even these situations in which disclosure may be denied apply when other criteria are met. Disclosure must also constitute a violation of the Constitution. If the information requested can be separated from the body of information subject to the exemption, if public interest in release of the information outweighs harm to the protected interest, or if the information was requested by any committee or house of the legislation or legislature for use in executive session, it must be released. The Senate Majority Leader Juan Miguel Zubiri stated that the new law promotes the right of all Filipinos to have access to all public documents. And this law is crucial for transparency and credibility of the next administrations. International laws, state and local regulations. So, in addition to the national and international restriction placed on an original use of computer technology, each state or locality may have a number of its own applicable laws and regulations. Information security professional must therefore understand state laws and regulations and ensure that the organization security policies and procedure comply with those laws and regulations. So international laws and legal bodies, no? It is important for IT professional and information security practitioner to realize that when their organizations do business on the internet, they do business globally. As a result, this professional must be sensitive to the laws and ethical values of many different cultures, societies, and countries. So while it may be impossible to please all of the people all the time, dealing with the laws of other states and nations is one area where it's certainly not easier to ask for forgiveness than for permission. A number of different security bodies and laws are described, of course, and because of the political complexities of the relationship among nations and the difference in culture, there are currently few international laws relating to privacy and information security. The laws discussed but not limited in their enforceability. Agreement on trade-related aspect of intellectual property rights. That TRIPS, created by the World Trade Organizations and negotiated over the year, introduced intellectual property rules into the multilateral trade system. It is the first significant international effort to protect intellectual property rights. It outlines requirements for governmental oversight and legislation of WTO members countries to provide minimum levels of protections for intellectual property. The WTO, or the World Trade Organization, TRIPS, or trade-related aspect of intellectual property rights agreement cover 5 issues. Number 1, how basic principles of the trading system and other international intellectual property agreements should be applied, how to give adequate protection in intellectual property rights, how countries should enforce those rights adequately in their own territories. Number 4, how to settle disputes of intellectual property between members of the World Trade Organizations, and a special transitional arrangement during the period when the new system is being introduced. The Digital Millennium Copy Act, or DMCA. DMCA is the American contribution to the international effort of the World Intellectual Properties Organization, or WIPO, to reduce the impact of copyright, trademark, and privacy infringement, especially when accomplished via the removal of technological copyright protection measures. This law was created in response to the 1995 adoption of Directive 94/46/EC by the European Union, which added protection for individuals with regards to the processing of personal data and the use of movement of such data. DMCA includes the following provisions. Prohibits the, number one, prohibits the circumventions, protections, and countermeasures implemented by copyright owners to control access to protected content. Number two, prohibits the manufacture of devices to circumvent protection and countermeasures that control access to protected content. Number three, bans trafficking in devices manufactured to circumvent protection and countermeasures that control access to protected content. Number four, prohibits the altering of information attached or embedded into copyright materials. And number five, exclude internet service providers from certain forms of contributory copyright infringement. Ethics in information security. Many professionals, groups have explicitly rules governing ethical behavior in the workplace. Let's say, for example, doctors and lawyers who commit egregious violations of their professions, canons of conduct can be removed from practice. Unlike the medical and legal fields, however, the information technology field in general, the information security field in particular, do not have binding code of ethics. Instead, professional or associations such as the Association for Computing, Machinery, and the Information System Security Associations, and certification agencies such as International Information Security or System Security Certification Consortiums work to establish the profession's ethical codes of conduct. So while this professional organization can describe ethical conduct, they do not always have the authority to banish violators from practicing their trade. So to begin exploring some of the ethical issues particular to information security, we need to take a look with this 10 commandments of computer ethics. As an IT practitioners, of course, we need to know this one. And we need to be familiarized for us to know what is right and what is not right. The ethical difference across cultures. Cultural differences can make it difficult to determine what is and is not ethical, especially when it comes to the use of computers. Studies on ethics in computer use reveal that people of different nationalities have different perspectives. Difficulties arise when one nationality's ethical behaviors violates the ethics of another national group. Software license infringement. The topic of software license infringement or piracy is routinely covered by a popular press. Among study participants' attitude toward piracy were generally similar. However, participants from US and the Netherlands shown statistically significant difference in attitude from the overall group. This could mean that the individuals surveyed understood that software license infringement was, but felt either that their use was not piracy or that their society permitted this privacy in some way. Peer pressure, the lack of legal incentives, the lack of punitive measures, and number of other reasons could explain why users in this alleged piracy centers disregarded intellectual property laws, despite their professed attitudes toward them. Even though participants from the Netherlands display a more permissive attitude toward piracy, that country only ranked third in piracy rates of the nations surveyed in the study. Illicit use. The study respondents unilaterally condemned viruses, hacking, and other forms of system abuse. There were, however, different degrees of tolerance of such activities among the groups. Students from Singapore and Hong Kong proved to be significantly more tolerant than from the United States, Wales, England, and Australia. Students from Sweden and Netherlands were also significantly more tolerant than those from Wales and Australia, but significantly less tolerant than those from Hong Kong. The low overall degree of tolerance or illicit system use may be function of the easy correspondence between the common crimes of breaking and entering, trespassing, theft, and destruction of property and their computer-related counterparts. Misuse of corporate resources. The scenarios used to examine the level of tolerance for misuse of corporate resources each presented a different degree of non-company use of corporate asset without specifying the company's policy on personal use of company resources. In general, individuals displayed a rather lenient view of personal use of company equipment. Only students from Singapore and Hong Kong view personal use of company equipment as unethical. It is interesting to note that only participants among the two Asian samples, Singapore and Hong Kong, reportedly generally intolerant attitudes toward personal use of organizations' computing resources. Ethics and education. Attitude toward the ethics of computer use are affected by many factors other than nationality. Differences are found among individuals within the same country, within the same social class, and within the same company. Key studies reveal that the overriding factor in leveling the ethics perception within a small population is education. Employees must be trained and kept aware of a number of topics related to information securities, not the least of which are the expected behaviors of an ethical employee. And this is especially important in information security, as many employees may not have the formal technical training to understand that their behavior is unethical or even illegal. Proper ethical and legal training is vital to creating an informed, well-prepared, and low-risk system users. Deterring unethical and illegal behavior. There are three general causes of unethical and illegal behavior. Number one, ignorance. Ignorance of the law is no excuse. However, ignorance of policy and procedure is. The first method of deterrence is education. So this is accomplished by means of designing, publishing, and disseminating organization policies and relevant laws, and also obtaining agreement to comply with these policies and laws from all members of the organizations. Reminders, training, and awareness programs keep the policy information in front of the individual and thus better support retention and compliance. Number two is accident. No? Individuals with authorization and privileges to manage information within the organization are most likely to cause harm or damage by accident. Careful planning and control helps prevent accidental modification to systems and data. And number three, intent. Criminal or unethical intent goes to the state of mind of the persons performing the act. It is often necessary to establish criminal intent to successfully prosecute offenders. Now, protecting a system against those with intent to cause harms or damage is best accomplished by means of technical controls and vigorous litigations or prosecutions if this control fails. So, whatever the cause of illegal, immoral, or unethical behavior, one thing is certain. It is the responsibility of information security personnel to do everything in their power to deter these acts and to use policy, education, and training and technology to protect information in systems. Many security professionals understand the technology aspect of protection, but underestimate the value of policy. However, laws and policies and their associated penalties only deter if three conditions are present. Number one, fear of penalty. Potential offenders must fear the penalty. Threats of information reprimand or verbal warnings may not have the same impact as the threat of imprisonment or forfeiture of pay. Number two, probability of being caught. Potential offenders must believe there is a strong possibility of being caught. Penalties will not deter illegal or unethical behavior unless there is reasonable fear of being caught. Number three, probability of penalty being administered. Potential offenders must believe that the penalty will in fact be administered. Codes of ethics in professional organizations. A number of professional organizations have established codes of conduct or code of ethics that members are expected to follow. Code of ethics can have a positive effect on people's judgment regarding computer use, and unfortunately, many employers do not encourage their employees to join these professional organizations. But employees who have earned some level of certifications or professional accreditation can be deterred from ethical lapses by the threat of loss of accreditation or certification due to a violation of a code of conduct. Loss of certification or accreditation can dramatically reduce marketability and earning power. It is responsibility of a security professional to act ethically and according to the policies and procedures of their employers, their professional organization, and the laws of society. It is likewise the organization's responsibility to develop, disseminate, and enforce its policies. Many of the organizations, other certification programs that require the applicants to subscribe formally to the ethical codes. This will be the major IT professional organizations. Many of the major IT professional organizations maintains their own codes of ethics. And of course, a majority of us are familiar with the Association of Computing Machinery. It is a respected professional society that was established in 1947 as the world's first educational and scientific computing society. It is one of the few organizations that strongly promotes education and provides discount for student members. The ACM Codes of Ethics requires members to perform their duties in a manner befitting an ethical computing professional. The code contains a specific reference to protecting the confidentiality of information, causing no harm, protecting the privacy of others, and respecting the intellectual property and copyrights of others. The ACM also publishes a wide variety of professional computing publications, including the highly regarded communications of the ACM. And we have the International Information System Security Certification Consortium. This is a non-profit organization that focuses on the development and implementation of information security, certification, and credentials. And we have also the ISA, ISC2, GIAC2, GIAC, and others. So I think that's it. To summarize, the laws are formally adopted rules for acceptable behavior in modern society. Ethics are socially acceptable behaviors. The key difference between laws and ethics is that laws carry the authority of a governing body and ethics do not. Organizations formalize desired behaviors in document called policies. Policies must be read and agreed to before they are binding. Civil law comprises a wide variety of laws that are used to govern a nation or state. Criminal law addresses violations that harm society and are enforced by agents of the state or nation. Private law focuses on individual relationship, and public law governs regulatory agencies. And that's it. And I would like to thank our reference, Principle of Information Security by Michael Whitman and Herbert J. Matford. Preparing Tomorrow's Information Security Professionals. That is the 4th editions. Copyright by 2011 by Cengage Learning. All rights reserved again by Cengage Learning in 2011.